Good afternoon. This is the first of several Q&A sessions that we're going to be having to give people an opportunity to ask questions regarding the new Civil Rights Relocation Notice that was published and issued on November 10th of this year. I am going to give a very, very high-level summary of the major changes that this notice brought about. This is not intended to be a training on the notice. This is mostly a Q&A session. If you want more details on the notice itself, Tom Davis, the director for the Office of Recapitalization here at HUD, gave more of a deep dive into the training, and that training was recorded, and it is posted at the RAD resource desk. So if you want more information about the specifics of the RAD new RAD Relocation and Civil Rights Notice, I suggest you go there. So what I'm going over here is, and I'm going to go through it very quickly, is just a couple of slides from that presentation, just giving the overall impact of the new notice. As those of you who have read the notice, it's divided into two major parts: the fair housing and civil rights, and then relocation. The focus on the fair housing and civil rights is to provide focus and clarity on existing fair housing and civil right obligations and how they impact RAD transactions. I cannot emphasize enough that these requirements are not new, and that the PHA remains primarily responsible for civil rights compliance, as they always have. On the relocation side, you will see that there are additional resident protections. We're trying to streamline and facilitate the implementation of relocation, and we try to clarify the relocation requirements. In the prior notice, which was much shorter, there were a lot of questions left unanswered that the new notice addresses. So, to give you just a slightly deeper dive, the new requirements and changes on the fair housing and civil rights side are on the next slide. Okay. The first one will be in place once we have Paperwork Reduction Act approval. There will be a new electronic checklist that will, which we hope will help guide PHAs through the process and have a better understanding of what the RAD requirements are and what the fair housing requirements are. Okay. You will also see that there's a change in timing as to when materials have to be submitted. They have to be submitted earlier in the process. And now front-end civil rights review approvals are required for submission of a financing plan, not just required by closing. Okay. And again, the other change is that the approval of a pump is required for marketing, not closing. So you could close, but you would not be able to market until that approval was obtained. And then lastly, there is an explanation of the risk-based analysis, the front-end risk analysis that is being done by HUD to assess the risk of the transaction. That front-end risk assessment by no means exempts you from all the other civil rights and fair housing requirements. They are in place regardless. So it's just HUD's attempt to determine the risk of the transaction from a fair housing civil rights perspective. It is not to exempt you from all the requirements that you would otherwise be required to comply with. I cannot emphasize that enough. On the relocation side, this is a quick summary of the changes. The old notice did not clearly state who was eligible for protection, eligible for the RAD protection. It does now. You have to be legally residing in your unit. Okay. The old notice gave you a right of return, but didn't really tell you what that meant. The new notice is very clear. You have a right to return to a unit where you are either not underhoused or has the same major amenities. The next change, the old notice encouraged you to have a relocation plan, but did not require it for any transaction. If you have permanent relocation, i.e. temporary or permanent relocation, i.e. relocation more than 1 year, a relocation plan is required. It need not be submitted, and HUD is not requiring you to submit it, but you are required to have one and to make it available to HUD if we request it. On the notice side, there are two changes. There is now a RAD information notice, and that RAD information notice must be sent prior to either of the tenant meetings, which must take place prior to your CHAP application. And that notice is new. That notice is to let tenants know generally about the RAD conversion, and to let them know apprise them of the rights under RAD, such as the right to return. The GEN will be either sent at the same time as the REN, or on most cases, no more than 30 days after CHAP. And that will address the relocation plans that the PHA had. In addition to the addition of the REN, the PHAs are now required to give a notice to the residents who have relocated as to when they are going to be returned to their unit. And this was not in the prior notice at all, and there is a sort of rough rule of thumb that the notification should be sent at least approximately 15% of the time before they have to return. So if they're relocated for a week, a day's notice might be appropriate. If they've been relocated for 30 days, you take 15% of that. That's like at least 4 or 5 days notice. The idea here is that people should receive reasonable notification in advance that they are able to return to their unit, and that PHA should not be, moving people suddenly at the last minute. Okay. Relocation, tenant relocation has been greatly streamlined. Okay, and it mostly happens automatically now. There is no resident relocation under RAD prior to RCC, period. You can, if your deal involves acquisition, you can send out your notice of intent to acquire and your relocation notices prior to RCC, but you cannot move tenants prior to RCC. However, depending on the circumstances of your deal, if your notice is out on a deal involving acquisition sufficiently early, it is not possible for a deal with acquisition to move tenants after RCC issuance. For all other transactions, notices can be sent out after RCC issuance, and provided the time periods in the notices has expired, you could move before closing if the deal has not yet closed. Another major change is that PHAs are required to maintain resident relocation data. We've had far too many instances where residents have moved from the project and the PHAs didn't know where they went. So we are now requiring that PHAs maintain much stricter control in terms of documenting where the tenants go, what benefits that they're receiving, so on and so forth, and that's set forth in the notice. This next point, PHAs could, under the old notice, offer incentives for people to voluntarily relinquish their right to return to the project. But the old notice was entirely silent on what you had to do to achieve that process. The new notice makes clear that incentives do not include rights that tenants are entitled to under the URA. Incentives are over and above what would be provided to the residents under the URA. And there's also a lot of information, and I encourage you to look at the notice, which discusses how to make these offers and what would constitute an offer that would be acceptable to HUD. Okay. Finally, the notice explicitly permits the use of public housing units for temporary relocation under certain circumstances. Again, I'm not trying to be exhaustive about this. This is just a 30,000-foot view of the notice. If you want more information, again, I encourage you to go to the RAD resource desk and to listen to Tom Davis's presentation on the notice. Now, getting into the mechanics, which is much more what this session is really about. There have been a number of questions about the application of the notice. And I think the best way to do is to sort of take your transaction and sort of take a shot of it on November 10th, because the notice was issued and effective immediately. So, for example, if you had submitted a financing plan by November 10th, okay, the intent is not to have you retroactively issue something like a REN, because the time when you were supposed to have issued the REN, the notice wasn't out and didn't apply to you. So I wouldn't expect you to issue a REN, but HUD would expect you to have issued a GEN in accordance with the notice that was in effect at that time. So in terms of implementation or effect on deals that are in the pipeline, it depends on where you are in the pipeline or where you were in the pipeline as of November 10th. And wherever you are from that point forward, all the provisions that apply to your deal at that stage forward apply to you. Okay. Now, mechanically, because the new electronic checklist has not received Paperwork Reduction Act approval, PRA approval, in terms of processing and what you have to submit, it's pretty much what you've had to submit all along. There will be changes in the future, but right now we don't have approval for any new forms that we could require PHAs to fill out at this point in time. So that's my overview of the notice, very brief, and just a general discussion of the mechanics of how things are going to work on a going forward basis. So at this point, I think we're going to turn to the questions that we received. I think the first question that we went was applicability to units already converted. And I think I just finished addressing that question. You take a snapshot on November 10th of where your deal is, and you're responsible under the new notice from that point going forward. Okay. The next question we have here is the maximum amount of RAD units that can be converted. However many units you have in PIC is how many units you can convert as a general rule. So it's just whatever is in the PIC system. There's not much more I can say about it than that. We had another question on footnote 83, and I'm going to turn it over to Brian O'Neill with CPD to to begin to answer that question?
Yeah, hi. This is Ryan from CPD, and I'll try to address the question from the URA, Uniform Act standpoint. And generally, HUD views like a move within, either it be it a temporary move or a permanent move within the same building or complex, would generally not be subject to the URA, provided that such persons are reimbursed for their out-of-pocket expenses in connection with those moves, and that the terms and conditions of that move or those moves are reasonable. I think the actual question got into some inconsistency about what notice should be provided. Right. I'll let Claude address that.
Yeah, the new notice blends sort of recap program requirements and URA requirements to a much greater degree than the prior notice did. So in many instances, the RAD notice extends the URA protections to circumstances where the URA would not otherwise apply. In this particular instance, the notice, I believe, is pretty clear that under RAD, we don't consider moves within the same complex or building to be a relocation. So this is an instance where there would not be relocation under either the URA or under the RAD notice. Next question that we're going to deal with here. I'll read this out. I am currently living in senior housing in Las Vegas. I hear these offers are only for families with kids and no single disabled men, or never offered this. That's not true. We do have RAD conversions that are elderly only. It just depends on what the PHA decides to do and whether HUD accepts the proposal as part of their review of the transaction. It goes on to say that this person would like to move to their own home, and that's well and good, but that's not really part of RAD. Your PHA may offer you, opportunities for home ownership, but that would be outside of the RAD program. Okay. The next question is clarifying the question of how you satisfy the right to return. Okay. As a general rule, the right to return is a right to return in a multi-phase project. The right to return is the right to return to the phase in which you are located. The only exception to that is if you have multiple phases running at the same time. Then it is possible that your right to return could be to one phase or the other. But this is a very fact-specific determination because if those phases are not located next to each other, for example, there may be fair housing considerations, there could be URA considerations. But as a general rule, the right to return is the right to return to your phase. And to go beyond that would depend on the specifics of the transaction. Next question we're asked was someone who felt that their civil rights have been violated. Shiva from PIH.
We just have the 1-800 number that they can call to file a complaint if they feel their civil rights have been violated. That number is 1-800-669-9777, and this will all be on the resource center.
Okay. And then the next question is the site and neighborhoods. Julia?
Sure. The question was, it looks like the notice requires transfers of assistance to existing units to meet the same standard of minority concentration as new construction. The answer to this, the notice does have a new front-end review for transfers of assistance. to existing units, but it is not the same as the new construction site neighborhood standards review.
And the last question that we're going to answer that was submitted by one of the registrants is there a HUD sample notice available to notify residents of a final move in a RAD property? This is I'm not totally clear, but I'm going to assume that what the question is asking is there a form for a notice for being notified that you can now return to your unit? And the answer to that question is no. The prior notice did not require PHAs to notify tenants of when they could return to their units. The new notice says you have to provide notification, and that notification has to be reasonably before the time you would be asked to return. But there is no form for what form that notification should take, other than that it should be in writing. So those are the questions that we feel that we can answer. There were a few other questions that were not related to the notice. We will try and get back to people regarding some of those questions, but we really wanted to keep this question and answer to questions regarding the new fair housing relocation notice. And at this point, I would open it up to people to ask whatever questions they wish.
Great. It looks like our first question is from Darnell Jackson. Darnell, we've unmuted your line. You're on, unmuted your phone, rather. You're on the line. Darnell, you may need to unmute your line as well. All right, we'll come back to him. All right, next up is Edward Park. Edward, do you have a question?
No.
Oh, okay, all right. We'll put your hand back down.
All right.
All right, Ron Law, you're on the air.
The question that I have is, what is the process for obtaining HUD approval?
Ron, we can barely hear you.
What is the process for obtaining HUD approval of the use of other public housing as a temporary relocation resource?
Ron,
temporarily relocating people to other public housing units? Is that what it is?
Ron, could you, sorry, we had a hard time hearing you. Could you come closer to your phone or your headset?
Is this any better?
No. Do you want to put your question in writing?
Yeah, I'll do that.
Okay.
Yeah,
all right. Thanks,
great.
Ron. All right. It looks like those are all the hands that we have raised. We can turn it over to written questions.
Sure.
All right. We're just going through the written questions that folks have been typing in. Some of them are a little bit long, so we're just reading through them.
I guess I'm going to answer that question in very general terms.
Okay. Yeah, folks on the phone can't see the question.
Yeah.
Do you want to summarize it?
Skip the question.
I'll let you deal with this skip portion.
Oh, what question were you answering? The hot mode?
Yeah.
Oh, okay.
The question is going to threshold income families. And the way RAD philosophically deals with the situation is to say that you may have families who are over income for purposes of, say, tax credits. Okay. provides an absolute right to return. So the fact that you might be over-income for tax credit purposes does not alter your right to return to the project. The PHA would have several options in the instance of an over-income family. And remember, the right to return is the right to return without rescreening. In that instance that I gave, the PHA can either alter their plans to accommodate the over-income tenant. In other words, perhaps have a project that is partially covered by tax credits and partially not covered by tax credits, so that the over-income tenant could live in the portion of the project that did not receive tax credits and was not subject to the tax credit income limitations. Or the PHA could attempt to persuade the tenant to voluntarily relinquish their right to return to the project. And I would suggest that you look at the affordable housing, alternative housing options section of the notice for guidance on how to make an offer appropriately to a tenant so that they can consider whether they want to return to the project or not. Well, what happens for families that skip? Under RAD, you have to give the appropriate notices to all households. Under the old notice, it would be the GEN. Under the new notice, it would be the RENT and perhaps the GEN as well. The concern that HUD has is that we don't want people leaving the project without understanding the consequences of their leaving the project in the middle of a RAD conversion. That there are rights that they have that they would be sacrificing, such as the right to return to the project, and they should know about the PHA's plans for the RAD conversion. That you know, if you have a deal with a significant amount of tax credits, that you could be leaving a project that's getting ready to have significant capital improvements made to it, which might impact your decision as to whether to leave or not. That said, after residents have been notified, we can't require people to stay if they don't want to. So if you decide to leave after being told to be given the appropriate notices that contain the appropriate information, well, there's not much you can do. I would encourage PHAs, in case questions come up, to, as best they can, keep a record of where these people have gone to, if at all possible. And if that's not possible, I would certainly document the circumstances under which they left the project, in case questions arise later on.
Yeah, this is Brian O'Neill with CPD, and I'm just going to add on to what Claude had mentioned. Now, from a URA perspective, and I guess from RAD, let's just talk about RAD. We're looking at PHAs providing full information to residents to protect their rights. Okay, so you know, if we HUD want residents to know that they're fully aware what the project plans are. You know, when this is going to happen, what rights that they have as they're going through conversion. So as Claude had mentioned previously, this RIN, I guess the Resident Information Notice, is a new notice that has been required as part of the new Fair Housing Relocation Notice. And so that is basically the first notice of, hey, look, the project is coming, you know, we're putting you on notice. From a URA perspective, the GEN, which is a General Information Notice, that essentially says it provides people knowledge that there could be a federally funded project coming, where they could be displaced or maybe could be relocated, and these are their protections under the URA. So what we have been stressing as part of CPD is to make sure that that notice, specifically when there is acquisition, rehab, or demo involved, and you're projecting that there is going to be temporary or permanent relocation, that notice goes out. And so once that notice is issued and delivered to these people, to the residents, then they're fully aware of their protections that this project is coming. Now, in the event that, I guess, they skip, the question pertains to skipping. If they skip after receiving that notice, I think typically we would look at that saying, okay, well, that was their prerogative. They chose to skip. You know, we said that they should get this form. They were fully informed with that information. They chose to skip. But, you know, you should always document, just in case there's like, you know, a post-conversion monitoring or a complaint that you can actually document, you know, that this person was provided these notices and they skipped on X and X day.
Right.
So I don't know if there's anything to add on to that, Claude.
I think it would all depend on the circumstances, but I cannot emphasize enough the need to document situations like this, because HUD will presume that that's a displaced person unless there's documentation to the contrary.
Yeah, when we look at some of these projects and we see there's a lot of vacancy already, sometimes we'll ask, well, you know, why are all these units vacant? And then, you know, without having a good explanation, you know, be it that the person skipped or was terminated or, you know, record keeping. So just, you know, document everything as best you can.
Right. Because you are allowed to not really release or re-rent a unit once it is vacated by the resident. And there's nothing wrong with that. However, you should, for your own protection, document the reasons why a tenant left a unit in the middle of a RAD conversion.
Right, and just one closing comment on that. We, you know, after the full information, we want to make sure that the resident left voluntarily, that they weren't forced out because of the RAD conversion to try to vacate these units. So, you know, that's kind of our perspective, the CPD perspective, you know, what we're looking at.
Right. Now, the next question.
Okay. Looks like we've got a hand raised from Amanda Abrahamson. Amanda, you're on there.
Hi, I just wanted to ask, is the GIN the same as the notice of non-displacement?
No, they're separate notices. You now have you could have three notices for this process. You have the RIN, which has to be provided to the residents before the first or second tenant meeting, which is done prior to CHAP application. You have the GIN, which may be provided at the same time, but typically no later than 30 days after CHAP. The notice of intent to acquire allows you to send out your relocation notices. You can only send out a notice of intent to acquire if you have an acquisition. The reason why a PHA would want to send out a notice of intent to acquire is because it allows you to send out the relocation notices much earlier than you otherwise could. You can send out your notice of intent to acquire approximately 90 days before you reasonably expect your deal to go before RCC. So, say you have a deal with acquisition. When you estimate that you're about 90 days before going to RCC, you can issue your notice of intent to acquire. At the same time, if you have relocation, you can issue your 90-day permanent relocation notice or 30-day relocation notice at the same time, so that once you have RCC issuance, provided that the time periods in those notices have also expired, you can begin relocating your tenants immediately.
Okay.
Sure.
What was the first notice?
You're talking about the notice of intent to acquire?
I
Or
thought
you're
that
talking
was the second notice.
The first notice is
So
always,
I heard there were 3 notices, but there were
Right.
2 that can be sent at the same time.
the two that can be sent at the same time are the notice of intent to acquire and your relocation notice, whether it's 30 or 90 days. But the acquisition is what allows you to issue a notice of intent to acquire.
Yeah, Amanda, this is Brian O'Neill with CPD, I think you had asked about a notice of non-displacement. I just want to clarify that a notice of non-displacement is a general rule for HUD programs, with the exception of RAD, would be provided or is expected to be provided to in projects where persons aren't going to have to move or only have to move temporarily and can come back to the project. Now, for purposes of RAD, under the first RAD relocation notice that was issued in 2014, the department had made the determination that a notice of non-displacement did not apply and should not be used in the context of RAD conversions. So there's no requirement or expectation to use a notice of non-displacement, as maybe you might be familiar with it from working other programs for RAD. I don't know if that answers your question.
Yes. Thank you.
Well, if you don't have relocation, you wouldn't need to send it. Yeah, let me read the question. What if you don't have to do relocation? Do you still have to submit a relocation plan and send out notices? The answer is no. A relocation plan is only required if you have relocation of more than 1 year. If you don't have relocation, you don't have to send out relocation notices because you have no tenants to notify. So and the final point I want to make is that you don't have to submit the relocation plan at any time. You just have to have it and have it available should HUD request it. I hope that answers the question. Yeah, we don't have to get back to you on that front-end civil rights question. It's not a question that we're prepared to answer at this time, but we'll look into it and get back to the person who asked that question. Okay. If you look at the new notice, it says that the RAD protections apply to anyone who was legally residing in the project at the time of application or at any time during the conversion. So if let's say the project was 100% occupied, somebody moved out, and someone else moved in. As long as they moved in sometime between the application and the RAD closing, they would be entitled to the protections under RAD. Okay. Claire, this is a good question. Does the right to return have to be the right to return to the same unit, or can it be to a unit that is comparable to the one previously in? The answer is the latter. The right to return is the right to return to the project. It's not the right to return to a specific unit in the project. The requirements are that the unit be one where they are not underhoused or has the same general amenities as the unit that they were in prior to the conversion. So if the tenant was in a 2-bedroom unit, a 2-bedroom, 1-bath unit, they would have the right to return to a 2-bedroom, 1-bath unit in the converted project, but not to any specific 2-bedroom, 1-bath unit in the project. This is the Violence Against Women's Act. I think there's only one reference to that in the notice, and okay, I'm sorry, I keep having to be reminded. Are there any additional requirements if a tenant during a RAD conversion applies the Violence Against Women's Act rule? Okay. The only reference that I'm aware of to the Violence Against Women's Act rule is that if a woman is subject to violence under that rule, that tenant can be moved at any time in the process, and they need not wait until certain things take place. The thought being that if her physical safety is in danger by remaining in the project, she can move immediately. We're not going to require a person to whom that rule applies to wait for RCC, for example.
And just to piggyback on this, my name is Tiffany Johnson, and I work in OPHPP. Oh, hi, my name is Tiffany Johnson, and I work in OPHPP. In addition to the notice under RAD, there was also recently a new VAWA notice that was put out at I believe on the same date, November 10th. So please reference any questions that you have. And it's not just a notice that goes for violence against women, but it's the violence against persons. So there's an extension to other, it's gender neutral. So just take a look at that if you have any specific questions about VAWA provision.
But for purposes of RAD, any person covered by that rule would be able to move immediately.
Exactly.
And would not have to wait for certain events to happen. If the new notice permits use of public housing units for temporary relocation, what was the allowance beforehand? The prior, I'm not sure I understand the question. The prior notice was silent on the use of public housing units for relocation at all. The new notice makes clear that public housing units can be used for temporary relocation, and it goes and it states how that should be done. Ideally, it should ideally be using units primarily in the project that is being converted, and secondarily only for their portfolio. And there are a few other requirements in there as well. But I would just encourage you to read that section because it is specifically addressed now. And it's one of many areas where this new notice addresses questions that were never addressed in the old notice. We'll have to get back to you on that next question.
There was a question about obtaining HUD approval for the use of public housing units during temporary relocation, so we're gonna come back to that one.
Yeah.
Before, if they move before closing, no approval is needed, but we'll get back to you after closing maybe.
Okay. If a family was previously overhoused in a unit, do they have the right to the same number of bedrooms, or only what's in compliance with occupancy standards? You have a right to return to a unit in which you are not underhoused. So if you were in a 4-bedroom unit, but your family size was really appropriate for a 3-bedroom unit, you have a right to return answer that question. How long should PHAs retain relocation records? I don't believe the notice sets forth a specific time period. I would certainly encourage you to maintain them for a number of years because HUD is going to do some checks of RAD conversions post-closing. I can't tell you how far back we're going to go, but I would encourage you to have your records and keep them, which shouldn't be that challenging in the electronic age.
Yeah, and can I just add on to that? Now, under the Uniform Act, I believe the record-keeping requirements of like 3 years after relocation. But you know, we'll have to maybe get back to you on the specifics. One thing that you might want to also check into are the various HUD program requirements. Be it that these might be PBV or PVRA. They may have their own specific record-keeping requirements. But I don't know how RECAP wants to weigh in on that. But you might want to check also any specific program-related record-keeping requirements. But you know, it just gets back to maintaining good records and keeping it for at least a minimum period of time, whatever that may be.
Right, right. Can electronic documentation be 100% electronic? I think the answer to that question is yes. I mean, you can have tenant forms in PDF stored electronically. I mean, the law has moved very much towards treating electronic records the same as physical records.
Yeah, you'll probably, like for forms, like for proof of delivery and things like that, you just want to make sure that you maintain executed copies of those forms that would show a signature, show proof of delivery, and make sure that those electronic records are accessible in the case of like a review, a post-conversion review, or even during conversion for HUD or somebody else to access that.
Right. We would expect you to contemporaneously make your records and maintain them for inspection by HUD as requested by HUD at any time. What we generally want on important notices like right to return and certainly for relinquishment of your right to return to the project is we would want execution by the head of household. We would want the right to return notice to be signed for by the head of household. What we don't want is people putting notices under doors and thinking that's sufficient, or giving it to somebody's, teenager, hoping that teenager will provide the notice to the head of household. I'm not quite sure I understand this question.
I do.
Okay.
Again, this
Could you just read it off?
This is Tiffany Johnson, and the question is, if a family qualifies for phase-in during a RAD conversion, and I'm assuming it's phase-in rent during a RAD conversion, and later has a decrease in their income, and the tenant portion is now lower than the TTP that qualified them for the phase-in, would that family then no longer qualify to continue on the phase-in rent calculation? that seems like a logical conclusion because these are all subject to change based on the tenant or the family's income at the time of recertification or during an interim. So if they no longer meet the criterion and their rent has decreased to such a number that they would be paying little to no TTP, then they should not be a part of the phase-in. If you have additional questions, please let us know.
Next question is, generally, there is no rescreening of RAD. However, if a resident is in legal status before conversion and owes back rent, can the PHA move to evict the individual without violating resident rights or otherwise causing issues under RAD? And the answer to the question is, it depends. Okay. A PHA can, at any time, evict a public housing resident pursuant to their administrative procedures for such things as failure to pay rent. What we don't want to see is a PHA which has allowed residents to owe back rent, and then once they decide to do a RAD conversion, then they decide to start evicting people. We would take the position in that latter situation that you really are just getting rid of people to make room for your RAD conversion, and you really didn't care about the fact that residents owed you rent. So it depends. If you are generally, evicting people for back rent, then you can evict people under your public housing rules and regulations.
And again, this is Tiffany Johnson, and all of these things would be found in your, especially if you're converting from public housing to the voucher side of the shop, so going to PPD, you need to place all of these items in your administrative plan. So if you're going to make, what is your criterion for eviction? What is your criterion for families that owe? All of these things need to be stated in your admin plan. So make those adjustments accordingly.
Right, and I mean, eviction is a big deal. So, we're going to be very interested in ensuring that persons who were evicted have, been afforded all their rights and protections. From a URA perspective, the URA speaks to evictions as well. So you just need to be very, very careful. And, we absolutely don't want PHAs to be evicting folks because of the RAD conversion, and especially to avoid paying relocation or providing relocation assistance and payments.
Yeah. Eviction is a good example of where you really need good documentation to document what took place and what rights the tenants were provided with. This question, I think I addressed in, if we already have issued a GEN, do we need to issue a REN as well? And the answer is probably not. If on November 10th, you would already issued a GEN under the prior notice, the July 2014 notice, you are probably past the point in the process where you would be required to issue a REN. We're not going to retroactively require you to issue a notice that was not required at the stage at which you were at. Please spell and explain GEN REN, and it's RIN. It's General Information Notice and Resident Information Notice. The Resident Information Notice, which is new to the notice, must be sent to residents before the first or second tenant meeting, which is prior to CHAP application. Generally speaking, and there's more detail in the notice, the REN is to tell residents of general project plan and to make them aware of their rights under RAD. The major right being the right to return to the project. The GIN, the General Information Notice, may be sent at the same time as the RAD, but typically is not sent any later than 30 days after chat. The General Information Notice now is going to focus more on the resident's rights if there's relocation.
Right, and a GIN, the General Information Notice, it's a URA, a Uniform Act required notice that's to be provided to afford residents protection. I think the thing that folks need to understand by issuing a GIN, now the RAD notice speaks on when to issue a GIN, but a GIN is in no way obligating the agency, to say if I issue a GIN that you're eligible for relocation. It's just saying, hey, look, we've applied for federally funded federal funding. You may be displaced, you may be relocated. In the event that we get it and you have to be relocated or displaced, these are your minimum protections. We'll provide you subsequent notices later. So the GIN is a Uniform Act or URA requirement that is being applied also in the context of RAD because generally URA applies to RAD because of acquisition, rehab, or demo, and then the RIN is an add-on that's not necessarily a relocation notice.
Correct. Oh, yeah, go, please.
Hi, this is Sheila Cousins from Public Housing, and the question is, what is the trigger to do immediate move under VAWA, Violence Against Women Act, and is it a notice from the DA's office? The VAWA guidance that was just issued, I believe around November 10th, says we do not require third-party documentation if someone is a victim of domestic violence. So there is a form, it's a self-certification form that the victim may complete or other forms, but there isn't an exact notice of what is required, and it's not from the DA's office. So please refer to the guidance that was released around November 10th on HUD Approval.
And there's a follow-up question on the site neighborhood standards for transfer of assistance. The question is, it's clear that there are different standards generally for new construction and transfer of assistance. For minority concentration analysis, what standards, if any, apply to transfers of assistance that does not involve new construction? So the difference between the two analyses is that for new construction, you're looking strictly at whether the area qualifies as an area of minority concentration, and if so, whether it meets one of the two exceptions in the regulations that would allow for new construction in such an area. And for the transfers of assistance, what we're looking at is we're comparing the demographics of the census tract where the project is currently located and comparing it to where the census tract to where the assistance is being transferred to see if there is an increase or whether the new census tract has a significantly higher number of minorities or percentage of minorities in the census tract.
Okay. The next question is, after serving the required relocation notices and the PHA is paying for the relocation expenses, but a resident wants to move on their own, is the PHA required to pay their relocation expenses? You want to start?
This is a question from Desi Winter. I don't know, Desi, if you're on the line. It might be helpful if maybe you can shed some more light on the specifics of your question, or maybe write a little bit more about it to answer it. So the question relates to PHA is paying for relocation expenses, but a resident wants to move on their own. Is the PHA required to pay for their relocation expenses? As Claude mentioned before, it depends. It really depends on the situation. So, typically, if it's a permanent move from public housing to public housing, the PHA has the ability to actually do the move, perform the move for the resident, and the resident doesn't get a choice, unless the PHA wants to provide them that option. For permanent moves under the URA, the persons actually do get a choice. So under public housing, that applies in the URA context. But if you're moving, if you've got a public housing resident that might be, you're providing a housing choice voucher, for instance, or they're moving to private market, they're taking like an alternative housing option, and they're moving to private market. They actually get what's required under the URA, which would be a choice of either the URA fixed residential cost moving schedule or payment of their actual reasonable and necessary moving expenses. So they would get a choice. So, the PHA can't say, I'm gonna move you, you don't get a choice in these instances. So I don't know if that helps, but probably if we got some additional information, it would be helpful.
The question is related to relocation. Who at HUD approved formal requests for HUD approval of public housing as temporary relocation resource after RAD conversion? The notice mentions consulting PIH. Does the PHA submit formal requests to the RAD transaction manager or to PIH? The PHA can submit the request to the local field office with a copy to the transaction manager, and further guidance will be posted to the RAD resource desk. But your local public housing office with a copy to your TM would be the best place to submit that request.
All we can do is try and make sure everyone who's answering gets close to the phone. I'm not sure I understand this question. Is the relocation option in the approved relocation plan by default? Public housing has been approved. Any thoughts? I think there's more to the question.
Well, they were saying that if they submit a relocation plan and it's been approved, and that includes relocating public housing residents after conversion, does that mean it's approved? We will.
No, we don't. HUD doesn't approve relocation plans. You're required to maintain a relocation plan. You're not required to submit it unless HUD asks for it.
Right. Formal approvals come from your local public housing office.
Okay.
There was a question about, you are referencing PHAs. Do these same notices apply to the rent deduct conversion? And how about 202? So this notice, the relocation notice, only applies to component 1.
Correct.
And component 2
does not apply to component 2.
Yeah, and the reference, I guess I've been referencing PHAs. The first notice, I'm not sure what this one says, but PHAs could also include developers. So, it's whoever is undertaking the program. I don't know, Claude, is there anything additional in this notice?
I don't think this notice changes it. I think it can be the PHA or an entity in which the PHA is the controlling party. When a resident returns they are overhoused, will HUD allow the PHA to pay the 2-bedroom standard for 1-bedroom person?
That is yet to be determined, and I'm only speaking for a project-based voucher. Some things can come via waiver, a waiver request, which the PHA is very familiar with, but it's not guaranteed that approval will be made. So it's very important that you do set out a plan with residents and have right-sized units for tenants upon their return.
In terms of under RAD, under the right to return, you would be allowed to return someone to a unit where they were overhoused, but you would be expected to transfer that tenant to an appropriately sized unit as soon as one became available, and to pay the relocation cost from the overhoused unit to the appropriately sized unit.
Yeah, so the question is, what would happen if the affordable property evicts the family, but they have not violated the PBV program, and the PHA is allowing them to remain on the program? So that's essentially saying that the owner of this property, and we're assuming that this is not a PHA owned, that they've evicted the family for some reason. But the PHA wants to allow them to remain. That means then that the PHA is under the obligation to find them, or work with the family to find a new place to house them, albeit another PBV site if they've done a total conversion, or a public housing site. But I'd be very interested for the specific details of this question. And I would also just urge the PHA to make sure that their administrative plan is aligning with a lot of the standards, or if they want it to, aligning with the standards of the building, so that you wouldn't get these gross delineations between, you know, a tenant being not following guidance for the building, but following guidance for the housing authority.
I would just remind everyone that public housing tenants are public housing tenants until the RAD conversion has closed. So even though your development team might be different from the PHA, that development team would not own the project until RAD conversion, i.e. RAD closing. So the only person who could evict a tenant prior to RAD closing would be the PHA.
So we got this question again. The new RAD notice indicates that we can transfer RAD conversion residents to other public housing properties as part of the relocation aspect. However, we need HUD approval to do that. How do we accomplish that? What does HUD require to approve that? So at the present time, we haven't shared guidance on exactly what the formal process is, but you can submit your request to your local field office with a copy to the transaction manager if you'd like to transfer RAD residents to other public housing.
Their last question.
No hands? No more questions?
No more questions.
Okay. Well, thank you very much. If you have more questions after this session, you can submit them to the RAD resource desk. We are planning on having 2 more question and answer sessions. The next one will be in approximately 2 weeks, and we will notify people of the date and time by RAD blast, as we did for this one. And we're planning on having at least 1 more Q&A session after the holidays probably around the second week in January. Again, we will notify people of that by RAD Blast as well. Other than that, thank you very much.